Patrick joins us alongside distinguished professor at Touro University, Thane Rosenbaum. Oh, we had a little run-on sentence introduction, my friend. We sure did.
Which we've never done before.
Oh, we've never done that. But,
I did want to set this up just a little bit for Thane and Wendy and our wonderful audience. The one case that the former president was told is you're going to start this next March 4th. Now, keep in mind, there's also the Manhattan hush money case supposed to start March 25th, 3 weeks after that. Then you have the Mar-a-Lago classified documents case scheduled for May 20th. And then we don't know exactly when the Georgia election interference accusation case would be. This seems like an awful lot, Thane, for one time, leaving aside whether this person's running for president. And I'll throw in there, I think Greta was pointing out that there are millions of pages of documents to go through before this March case.
The March 4th case, right?
Yeah. So could you go into that? That seems kind of crazy. There's a lot at one time.
Look, Bob, Americans should be paying very close attention to this. Fundamental fairness to the accused, the panoply of constitutional protections that are afforded and available to people accused of crimes is a hallmark of our justice system. That's what we do. People who are murderers, we bend over backwards to give them every opportunity to show that they are not guilty. These constitutional protections of due process under the Fourth Amendment, the right to confront your accusers on the Sixth Amendment, the right to speak freely about an injustice you believe has happened to you under the First Amendment, these constitutional rights are not available to a former president. It really is, outrageous, and the implications of it should be frightening to all Americans. You may not like Donald Trump, but he's entitled to constitutional protections as a man who's accused of crimes. And let me just add one more point. His lawyer stood up in court yesterday and said, I want to put on the record I cannot be ready for trial in March. I'm just telling you right now, so that the record could reflect that. So he has opened up the door for an appeal to say, I just telling you right now, this is a case with 1 million documents, as you pointed out, and I can't possibly be ready. And we're supposed to be rushing these cases because 3 of them are going to take place by mid-May.
Yeah, Wendy, I want to get your thoughts specifically on that March 4th trial that the former president is trying to get moved. It is the day before Super Tuesday, which doesn't seem like that is a mistake.
No, it's interesting. We'll call it Super Monday, because not only does it not seem like it's a mistake, I think what Thane was articulating is nobody should be above the law. Nobody should be below the law. And by the lawyer standing up and basically setting up a potential IAC claim, ineffective assistance of counsel, they're making it sound like, the former president is below the law. Now, that is the defense position. The prosecution position, on the other hand, is this indictment is built for speed. It is streamlined. There are 4 counts. There's no named conspirators. In other words, it is designed to go full speed ahead on the rocket docket schedule. And that is what they're going to try to do. And that distinguishes this case from the others. I mean, the Georgia case, gosh, I don't know how we're ever going to set a trial date with 19 defendants. You can't get that many people in the same room. But this is one of those cases that is, if you look at all of them together, probably more designed to go quickly. Now, Trump's lawyers are going to argue, you can't appeal it. That's not the correct terminology. They're going to argue for a continuance. In other words, they're going to go before the judge and say, look, 13 million pages, we can't get through it, although they're arguing that they've seen many of these pages before. But how can you look at that sheer volume and say we're going to be able to analyze, digest, decide what we're going to use? So they are willing, probably, to set another court date to say, look, we cannot be ready, and here's why. If they have good cause, they'll get a continuance.
Okay. Now, one of the things they did, Thane, Mr. Trump's lawyers, is try to pick a 2026 date, which Tanya Chutkan, who is the judge, kind of scoffed at. So, okay, maybe that's too far. But here's what I'm wondering. Now, keep in mind, she's an Obama appointee. Not that this is what happens in our system, that she was approved by a 95-0 vote, okay? So what people are saying is, like Wendy was pointing out, he has the right to counsel. He has a right to be defended appropriately. His own lawyers are saying, we can't do the job. So who could change that?
So obviously they can appeal. But she said something else that I thought was very distressing, where she said, when his lawyer said, look, the man is running for the presidency of the United States, and there are these 4 cases all operating simultaneously. How can he possibly run for the presidency? And her response very casually was, look, I don't care about his day job. The most important thing is my courtroom, what happens in my courtroom. No, it's not. No, it's not. I don't agree with that. And I think appellate courts might say he has a right to run for the presidency. The founding fathers believed in the rule of law, but they also believed in representative democracy. And they're standing in the way of representative democracy. So yes, Bob, I think there are appealable issues here on First Amendment grounds, Fourth Amendment due process grounds. He's not be given a right to due process. And again, Sixth Amendment, the right to confront my accusers. You are not giving me a meaningful opportunity to be ready for these 4 criminal proceedings.
Wendy, final thoughts.
Final thoughts is those appellate arguments will be made after conviction. And that's what's going to tie up this case. Even if it were to be a conviction, that's what's going to tie it up till well past the election. So one way or another, we're not going to have a final result by 2024, whether or not that March trial date stands.
I guess what I'm trying to figure out, is there any way that March date shifts according to somebody that might be superior to them? Like the appeals court's not going to step in, right? There will be appeals, though, right?
Bob, I'm assuming, I don't know what Wendy thinks, I'm assuming that there is going to be an emergency petition to the Supreme Court. You're going to see it. It's going to be an emergency that's called it, and that's what they're going to be arguing.
If there were some kind of an appeal, it would not be on the trial date being set. It would more likely be on some evidentiary ruling or something of that. But I have to also say, whether or not it's going to be successful, there's no reason to think they won't give it a shot.
I think they'd be fun to talk with for a long time. I wish we had more time.
I wish we had more time. We never do.
All right, Wendy Patrick and Thane Rosenbaum, thank you very much.